Order. This is meeting number 6 of the Standing Committee on Access to Information, Privacy and Ethics. Our orders of the day are pursuant to Standing Order 108-3H6, Study on Allegations of Interference in Access to Information Requests. And our witness today from the Office of the Prime Minister is Mr. Guy Giorno, who is the Chief of Staff. I would just like to mention to the colleagues that as you know, the committee approved certain other agenda items to be dealt with should there be time at any meeting, and I've included them at the end here. But Mr. Giorno will be the first item of business until the committee is prepared to release him and move on. This morning, the Access to Information Commissioner tabled her report cards on 24 institutions. I think it was a tough but a fair report. I'm sure it will come to play in some of the discussions we have with Mr. Giorno. Sir, I understand that you have some brief opening remarks for the committee, and I see that we have a question first. Madam Davidson, please.
Thanks very much, Mr. Chair. I'm not going to take up much time here. I just wanted a clarification, and you partially answered it, I think, in your opening remarks. I was just wondering how long Mr. Giorno would be here, and then the second thing was on the third item of business on our agenda, discussion on the appointment process, just making it clear that is the process of doing it, it is not the appointments itself. Is that correct? That's correct. Okay. And with regard to the time frame, Mr. Giorno has come here at our request, and we're basically in the hands of the committee. The committee will, I'm sure, have questions for him, and when the committee has finished its work, he'll be excused, and then if there's time left, we will be moving on to other agenda. Thank you, Mr. Chair. Mr. Giorno, please.
Merci beaucoup, Monsieur le Président.
Thank you very much, Mr. Chairman.
On your re-election last month, and by congratulating Mrs. Davidson and Mr. Sixay on their respective elections as vice chairs. I'd also like to thank the committee for inviting me here today and for accommodating my request to appear at the earliest possible opportunity. As you and I just discussed, Chairman, I'll share this with the committee members. We met 30 years ago during the 1980 federal election campaign at an all-candidates debate in the riding of Etobicoke Centre, sponsored by my high school, Michael Power. The chair was present as an alumnus candidate, excuse me. He was running the neighboring riding of Mississauga South. And I was working my 14-year-old tail off for a candidate named Joe Cruden. And on election night, despite the majority victory for my then party, I was sorely disappointed that both Joe and the chair had lost very close races. But I guess history shows that my support was pretty irrelevant or insignificant, because by the time the chairman had started to rack up his 6 consecutive victories, I'd already moved on to the other party. And I don't think either of us would have imagined that we'd be meeting again 30 years ago, each of us in our respective roles. Nonetheless, I'm happy to be here today, very pleased, and look forward to responding to questions of committee members, particularly those related to my responsibility. Committee members will appreciate that as an unelected government employee hired under Section 128 of the Public Service Employment Act, it's not my place to speak for the entire government. As I often repeat, and some of the committee members will have heard me say this, though I bear the title of the Prime Minister's Chief of Staff, I'm still merely part of the staff. The supremacy of Parliament is ensured by the principle of ministerial responsibility, and that is the cornerstone of responsible government. The principle requires that those who exercise the constitutional authority of the Crown must be part of Parliament and responsible to Parliament. It is ministers, not officials, who exercise constitutional authority, and it's ministers, not officials, who are responsible to Parliament. When a government employee appears before a committee to answer questions, as I do today, those answers do not change the fact, do not alter the fact, that it is ministers, not officials, who are constitutionally responsible for the exercise of authority and who are responsible to Parliament. Expressed differently, the presence of an official like me and the answers that I give can assist in the answerability of ministers to Parliament, but do not sever the responsibility of ministers to Parliament. Chairman, on January 23, 2006, Canadians voted for change. They sent a message to all politicians that it was time turn over a new leaf and change the way that business was done in the federal government forever. The first legislative reform introduced by this government was the Federal Accountability Act, the most sweeping and most comprehensive anti-corruption law in Canadian history. It signaled the government's determination to clean up Ottawa after the sponsorship program. It changed the way federal political parties are financed. No more big money, no more secret trust funds, no more corporate and union donations. It cleaned up Ottawa's contracting, advertising, polling, and procurement practices to ensure that taxpayers' money is well spent. It gave real ironclad protection to whistleblowers who come forward with allegations of wrongdoing. Okay. Thank you, Chair. It ended the revolving door among ministers' offices, the bureaucracy, and hired gun lobby firms. And it strengthened the access to information law by nearly doubling the number of entities that are subject to access to information. As Prime Minister Harper said when the Federal Accountability Act was introduced, and I quote, "We are creating a new culture of accountability that will change forever the way business is done in Ottawa," end quote. The objective was to replace the old culture of entitlement with good, clean government, because that's what Canadians voted for on January 23, 2006. Now, the centerpiece of our anti-corruption law, or a centerpiece, excuse me, was strengthening access to information. The Honourable John Baird explained thusly on April 25, 2006, quote, "Canadians deserve better access to government information. The Government of Canada belongs to the people, and the government should not unnecessarily obstruct access to information," end quote. Access to information is the public's right. Subject to the Access to Information Act, every Canadian citizen and every permanent resident, quote, "has a right to and shall, on request, be given access to any record under the control of a government institution," end quote. All ministers have delegated their responsibilities under the Access to Information Act to specifically named public servants, and it is those specifically named servants, pursuant to delegations of authority, who are responsible for all decisions under the Act. No political staff member has received a delegation of authority under the Act, and therefore no political staff member has authority to make access to information decisions. The new Treasury Board policy on access to information, which replaced the weaker policy of the previous government, provides as follows in section 6.1.2. Quote, "Once an order," this refers to a delegation order, "once an order is signed, the powers, duties, or functions that have been delegated may only be exercised or performed by the head of the institution or by the named officers or employees," end quote. So to repeat, no political staff member has received a delegation of authority under the Act, and therefore no political staff member has authority to make access to information decisions. Political staff members are subject to the instructions issued under the authority of the Prime Minister in a book called Accountable Government, a guide for ministers and ministers of state. That book states, à la page 37, l'article 6.1,
on page 7, Article 6.1, political staff cannot give orders to public servants, but can ask them for information or transmit instructions from the minister by passing through the deputy minister.
Accountable government is a condition of continued employment for members of the political staff. In each department, it is public servants, not political staff members, who compile the records in response to an access request, who decide on and give notice of time extensions, who decide which mandatory and discretionary exemptions apply to any records, and who decide whether or not to invoke or apply a discretionary exemption. I cannot speak for the practice of all departments, but in the Prime Minister's department, that is the Privy Council office, after an access decision is made, And prior to release, the Minister's Office, that is the PMO, is informed of the fact that an access decision has been made and there will be release. The legitimate purposes of this advance notice, which in our case I understand usually occurs approximately 4 days prior to release, include to brief our minister on the content, to prepare to respond to questions in question period or from the news media, and to explain the content to anyone who might ask. The purposes of this advance notice do not include and must not include to alter the decision, to vet the content, or to delay, deny, or withhold access. However, this advance notice is entirely consistent with the constitutional responsibility of each minister for the operation of his or her department. An advance notice does not alter the fact that decisions about release, time extensions, and invoking exemptions are made by nonpartisan public servants pursuant to delegations of authority. I'll simply close by pointing that staff training has covered these points. It covered these points prior to my arrival. After my arrival in 2008, Accountable Government, which covers these points, has been reissued. And more recently, I've taken specific steps to reinforce these rules, including the rule that the Access to Information Act must be upheld, and the rule that it's improper for a political staff member to instruct public servants in the exercise of their authority. Those rules have been were trained, they were confirmed, recommunicated, and as recently as this year they've been reissued, recommunicated, so there can be no possibility of confusion. Chairman, I thank you and members of the committee for your indulgence, and I now look forward to answering any questions that members may have.
Okay. If I may, just for clarification, the document you referred to, the Prime Minister's Code of Conduct for Ministers, Ministers of State, public office holders, the person responsible for determining whether or not there is a breach is who?
Okay. So I'm referring to the document Accountable Government, Chairman. It's issued by the Privy Council Office under the authority of the Prime Minister. Questions about interpretation application are usually answered by the Privy Council Office. In the case of ministers, though, it's the Prime Minister is ultimately responsible for ensuring that a minister has or has not complied with it. In the case of members of the political staff, it would be each individual minister who is responsible for ensuring that his or her employees comply with it or for dealing with any cases of non-compliance.
Thank you for the clarification. We're going to go right to questions. Mr. Valeria, please.
Mr. Journo, thank you very much for coming before the committee today. Coincidentally, you're probably aware that there was just a press conference by the Interim Commissioner for Information, Susan Legault. Are you aware of that press conference?
I'm aware that it took place. I'm not aware of the content of her report. Okay.
Well, I'm somewhat surprised that on the tail of that report and on the tail of that conference, where really it was nothing short of a scathing indictment of this government's compliance with the Access to Information Act, that you would come in here and say that your record of your party should be met with approval of some sort. She reviewed 24 different ministries, and a majority of them failed. If you look at the record, indeed, there are some that she marked with an F, like Environment Canada, and Foreign Affairs and International Trade were off the chart and given a red alert. She said that the delays are tantamount to censorship. Now, you said in your opening remarks that really there's no interference by ministers, none whatsoever, that the decision really is by the Access to Information Officer. And yet at page 52 of her report under Natural Resources of Canada, she says, the combination of staffing instability, a diffuse delegation of authority, and senior officials being inappropriately involved in approvals resulted in an unacceptable level of access to information compliance at NRCan in 2008 and 2009. The deemed refusal rate doubled from 2007 to 2008. That indictment is endemic in a number of other institutions, a number of the other ministries that that she reported on. And we need to know by what authority do these ministers interfere? Because you said yourself it's the ministers and not the staff who are responsible. So by what authority do they interfere? Is it convention or legislation? Because I can't find the exceptions in the Access to Information Act that would, by my estimation, allow this kind of interference.
Thank you, Chairman, members of the committee. The position of the government is clear. The government expects that the Act will be upheld, that there will be full compliance. The Act requires that decisions about access be communicated in a timely fashion, and if not, there is a process under the Act for time extensions, and then there's a process for a right of, as you know, appeal to the Information Commissioner. So it's the government's expectation that there will be full compliance with the Act. Now, the member's question relates to delegations, and he, in his preamble, he suggested that all those delegations might be to ATIP officers. That, in fact, is not the case. Each minister has issued a different delegation. The names of the employees to whom functions have been delegated are in the delegation orders. Every department puts those delegation orders on its website, and the member will notice that different departments have different delegations. Some delegations are to ATIP coordinators, some are delegated to directors general. In some departments, the minister has delegated some functions under the Act to some levels of employees and some to others. So I can't comment on the range of delegations across the system.
Okay, Mr. Journal, let me ask you this then. When a request comes in, are certain requests flagged other than the normal request? Are they flagged in some way and sent to PCO or the PMO's office?
I can only speak for the Prime Minister's Department. In the Prime Minister's Department, the Privy Council Office, there is no amber lighting, red flagging, whatever you want to call it, system. There was one, and it was well documented under the previous government, and that's been eliminated.
Okay, so if they're looking at a request and they're making a decision as to what will be released and what won't be released, can you talk to us about the criteria or the parameters? Are they, whether written or unwritten, within which a decision is made to partially or completely prohibit the release of information?
Chairman, I'm a bit confused by the question. The criteria are in the Act. Those who have exercised a delegated authority are to comply with the Act and to uphold the Act. Other than that, I can't comment because it's not political staff members do not have authority to be making those decisions, to be interpreting and applying the Act.
Then let's speak to Mr. Sparrow's conduct specifically, which gave rise to the motion by Mr. Easter to have you appear before the committee. By what authority did he act to prevent the release of that information?
Well, first of all, it's important, Chairman, to get the facts clear. The case to which the member refers was not a case involving an access to information request. It involved the ordinary intercourse between members of the news media and officials in the government. It was a response to a reporter's request.
Can you tell me, Mr. Journal, what is known as the Issues Management Wing? Can you tell me what that is?
In the Prime Minister's office,
yes,
or Minister's offices generally?
In the Prime Minister's office.
Well, there are a number of functions in the Prime Minister's offices, as there have been in all Prime Minister's offices. The issues management staff is responsible for preparing the Prime Minister for a question period, for assisting the preparation of other ministers for question period, and because the House of Commons does not meet every day, but Canadians have a right to expect that questions are answered, and reporters have questions, on a 7-day, 24-hour basis. Even when the House is not sitting, there's no question period. They're helping to ensure that the Prime Minister has answers and that ministers answer those questions.
There was a report in the Hill Times, a story on March 1st by Jeff Davis, that the PMO Issues Management Wing routinely gives verbal directions to slow down, delay, or stop ATIP altogether, or to transfer ATIP to the centre. Is this true?
I will say the following. The rules are clear. My expectations are crystal clear. Political staff members are not to give direction to public servants, and the Access to Information Act is to be upheld. Now, Chairman, the member refers to an article in a newspaper quoting anonymous sources. I'm here today. I'm here appearing on the record. I'm here appearing before a televised audience in addition to committee members. I'm speaking in my own name. I stand by what I say. I will not indulge in anonymous gossip from sources who lack the certainty or the conviction to put their own names behind what they say. If the committee chooses to indulge that, the committee has the tools and the ability to chase that down, but I will not indulge anonymous gossip.
Madame Freeman, s'il vous plaît.
Bonjour, Monsieur Giorno.
Good morning, Mr. Giorno. Thank you very much for coming this morning to give evidence. Since you started your presentation with the manner in which you see the arrival of the Conservative Party in 2006 as a very positive change regarding transparency, I would like to underline that perhaps we're not all giving the same reading to this as you are. For many of the electors and people in the general population, I think that the entry into power of the Conservatives was the start, well, not of a new era, as was claimed, because I was looking over the weekend at the speeches being made to the effect that there would be a government that would be open, with integrity and transparent. Mr. Coughlin, the star at the time, who had been the instigator of the opening of the sponsorship scandal after the Liberal downfall that we're all aware of, and the sponsorship scandal that occurred, the government then presented itself as a government of transparency. However, I would like to underline that from all sides, there has been an evaluation after 4 years of a rather unusual situation. Madame Buzetti said in a broadcast that the parliamentarians were very concerned with the access of information under your government. Le Devoir noted that it took 300 days in order to obtain information regarding the Afghan detainees. The Globe and Mail, 32 months in order to obtain information. L'Agence de Presse had to wait an additional 82 days in order to obtain information regarding allegations regarding Mr. Christian Paradis' investigation. So everybody, therefore, is able to observe that there's been a multiplication in delays and that tremendous censorship is being exerted. And when a government undertakes this type of operations and by multiplying delays and censoring documents, it strikes hard at the foundation of democracy. That was the intentions of the journalist. I, as a parliamentarian, also see the last 4 years under your Conservative government, when a government is prorogued at the very center of a storm involving the Afghan prisoners and the environment incidents at Copenhagen, and when Parliament is shut down so as to avoid answering questions on these important issues, it's also striking hard at democracy. And when we here as a committee, we worked for 3 months in trying to make recommendations regarding the Access to Information Act, by having all the witnesses, Mr. Marlowe, going back to all of the amendments proposed to improve the Act, and when we received a mere one-page report from Mr. Nicholson who said, go back to your work, I think that what we're doing here is once again defying the parliamentary system. And that presently, I forgot to mention, I said to you that the Devoir, the Globe and Mail, and the Canadian Press had delays, but the Ottawa Sun said Harper reigns as a monarch over the democracy which is dying. So my question then is the following. At the moment, there are allegations of political interference on a systematic basis from the PMOs in order to block access to information and release of information. Under 67.1 of the Access to Information Act, it states, and I would like to point this out to you, that nobody has the right to deny access under the present allegation, modify a document, or even hide a document, or order, propose, or advise, or bring in any other manner a person to carry out such activities, such as modifying or hiding a document. And anybody who is guilty of a criminal act, please let me finish.
You're already 5 minutes into it, and I really must allow the witness an opportunity. Please.
Point of order. There is a comment made by Madam Freeman about the Prime Minister, and I just call it to Rules of Order Decorum on page 614, Chapter 13. The remarks directed specifically at another member which questions that member's integrity, honesty, or character are not in order. And so I'd ask that her comments that she read, which was an indirect quote, quoting from a newspaper, is not in order to be defaming someone's character at this committee.
Okay. I don't believe the member intended to defame. She was quoting an article, but I caution all members just to treat the situation with respect and dignity, and the witness, of course, and let's move on, please. Thank you, Mr. Bazin.
Alors, devant telles allégations,
So, when faced with these allegations, these are serious because there have been 3 primary investigations carried out by the Access to Information Commissioner. The Prime Minister should call for an investigation by the RCMP, as he has done for Ms. Gerges, because these are very serious allegations which are presented here with Mr. Paradis.
We're already 6 minutes into this, but I want you to take the time that you need to respond to the things. I'll give you the time. It's acceptable to the members, but we need to keep our time frame under control. Please.
Thank you, Chairman. I'll try to be brief, just because the member touched on a number of points. The first is that the member referred to Section 67.1 of the Access to Information Act. That is, in fact, the law. As recently as February, I communicated that to ministers, chiefs of staff by sending out a memorandum which confirmed the provisions of accountable government to which I've referred, which confirmed the need to uphold the Act, and in fact reminded them that and their staff members that Section 67.1 of the Access to Information Act makes it an offense to obstruct the right of access, and that was a memorandum I sent on February 9th. I followed that up with subsequent training for the staff members of ministers who are responsible for issues management. I appeared before a special one of their regular meetings and addressed Access to Information Act, the Access to Information Act, my expectations, and touched on some of the points the member has raised. I think the record shows that the government has in fact introduced many positive reforms to access to information. The member refers to responsibility. It was this government which, in the Federal Accountability Act, added subsection 4.2.1 of the Act, which places on heads of institutions, that's ministers, the responsibility to ensure that there is timely, complete, and accurate disclosure of records without regard to the identity of a requester. And that was a reform of this government. And of course, the government's access to information policy was strengthened to that effect. It was in fact this government which brought in the Federal Accountability Act a requirement in the statute to have the responsible minister compile statistics so that members and the media and the Information Commissioner can ask the sorts of questions that are being asked. And I'll simply close by stating that the time frame for compliance is an issue, and it's not something of no concern. It's the government's policy that departments are to respond in the timeframes which are contained in the Act, or to extend time in accordance with the Act, subject to the right of a requester to go to the Information Commissioner and ultimately to the federal court. So it's obviously something of concern. Otherwise, the government wouldn't have proceeded with the Federal Accountability Act and would not have strengthened the access to information policy in the way in which it did.
Mr. 6A, please.
Thank you, Chair, and thank you for being here today, Mr. Journo. I'm sure you're a very busy guy, and I'm sure you had many other things you could be doing this morning, so thank you for coming. I want to echo what other members have said, given our concerns about in the initial request around this issue, but also given the Information Commissioner's report card today. I think many of us are very concerned that there is a developing culture of secrecy, a fairly highly developed culture of secrecy, that there has been mounting inattention to transparency on the part of this government. And many of us believe that access to information and the ability of Canadians and others to see the information of government is the oxygen of our democracy, and we're concerned that depriving our democracy of that oxygen is a very, very serious issue. The Information Commissioner's report today is very serious indeed, and the fact that the Privy Council office gets a D in that report, I hope, is very concerning to you and your colleagues. The fact that one department, Foreign Affairs and International Trade, was so bad the Commissioner couldn't even find a way to rate it in the scale of her exercise, and had to issue a red alert, is also extremely concerning, and something that I hope is demanding the immediate attention of government. That being said, I wanted to ask some specific questions. You described the notification process that happens when an access request is ready to be released. You talked about 4 days notice that's given. There's been some concern that that notification process has in fact turned into a consultation process where staffers have tried to convince officials to release less information, have made suggestions that it might damage relations with another level of government, a provincial government or a foreign government, as a way of diverting it to the Privy Council office and further delaying it. Can you comment on the fact that the notification process seems to have morphed into something other than mere notification, so a department can prepare an appropriate response to released information?
Chairman, I'll begin by saying that I accept and agree with the Mr. 6A's comment that access to information is the oxygen of democracy. In fact, this is principle the government adopts, and it's been made clear by the Supreme Court of Canada in decisions such as the DAG decision. And the Supreme Court of Canada has actually said and recognized that access to information law has quasi-constitutional status precisely because it's access to information which makes our democracy function and allows citizens to hold people in public office accountable. Now, a specific question of the member related to advance notice, and I said I can only speak to our office, and the 4 days to which I referred was an average approximately in our office, 4 days. But in general, it's important to remember that there is nothing wrong with that. The former Deputy Information Commissioner, Mr. Alan Leadbeater, had the opportunity to appear before this very committee on October 2nd, 2006, and I'm referring to the committee's evidence, number 8, 39th Parliament, first session, at page 5, where the former Deputy Commissioner was asked about this very point and said as follows, I quote, "We have no objection to government communication functions or ministerial staff knowing what information is going to be released under the access to information so that they can be prepared with house cards and Q's and A's and so forth, as long as the process of doing that does not prejudice the requester by either delaying the answer going out or by changing the amount of censoring that's in the document and so forth. That process, I think, can flow without there being any exchange of identities, and some departments do it very well. So no, as long as timeframes are met under the statute and it is properly applied, we don't have any problem with sensitive requests being routed through the communications function of a department." End of quotation. That is the former Deputy Commissioner's interpretation of the Act, and it's one that I think is correct.
Mr. General, do you think timeframes are being met with regard to release of access to information requests?
Chairman, any question about timeframes needs to take into account the fact that while the statute sets out timeframes, the statute also provides a proper mechanism for extending timeframes, and then it provides a mechanism for a requester who has a problem with that to turn first to the Information Commissioner and second to the federal courts. Subject to that comment, obviously it is not just the policy of the government, the position of the government, it is my personal view that, of course, subject to that, timeframes are supposed to be met. And that's why the government, as I've already said, introduced an amendment in the Federal Accountability Act to the Access to Information Act to add a new subsection that wasn't there before, to make heads of departments, i.e. ministers, responsible for accurate, complete, and timely responses to requests.
Mr. Giorno, has a minister ever lost their job because of inadequate response to access to information? Would the Minister of Foreign Affairs be in jeopardy today because of the Information Commissioner's report?
Order. Mr. Chair, Mr. Siske is asking a question that deals with things outside of his realm. And as he stated earlier, he was hired under the Public Servant Act. And in O'Brien Bosk, Chapter 20, O'Brien Bosk, Chapter 20, page 1068, it says particular attention is paid to the questioning of public servants. Committees or public servants have been excused from commenting on the policy decisions made by government. So if we're going to start asking these types of questions, it's definitely outside of the realm of Mr. Giorno, our witness, to comment on those, and I think that he should be excused from answering it. And committees ordinarily accept the reasons that public servants give for declining to answer a specific question or series of questions which involve the giving of a legal opinion which may be perceived as a conflict of interest with the witness's responsibility to the minister. So I think that definitely applies here. He is hired under the Public Servant Act, and that line of questioning is out of order.
I think that thank you for the citation. In committee, the members can ask questions they feel are appropriate, and should it be inappropriate in the view of the witness has that opportunity to make that point. And but if Mr. Giorno is prepared to address the question, or at least the part of the question that he feels is relevant, then he can do so. So this is really a matter for the witness to determine. Okay. Mr. Sixe, you have about a minute and a half.
Mr. Giorno, I don't know if you want to respond.
Well, I think in part, Chairman, I've answered the question. The expectations are clear, the policies are clear, and they are continually communicated. And we have a stronger, more robust access to information regime today, in the year 2010, than we did in the year as recently as 2005.
Well, it will be interesting to see where performance on access to information fits into the Prime Minister's assessment of his own ministry. Mr. Giorno, does the PMO yell at ministers' offices when more information is released than the PMO thinks is appropriate?
Well, my expectation and the Prime Minister's expectation is that his rules be upheld, and the rules in accountable government are quite clear. Access to information is the public's right. Access decisions, Chairman, are delegated to specifically named public servants. No political staff member has received a delegation of authority under the Act, and therefore no no political staff member has authority to make access to information decisions. It would therefore follow that one should not suffer any consequences for observing the standards in accountable government, which are that you don't instruct public servants and you respect the Access to Information Act.
Waliev, please.
Thank you, Mr. Giorno, for appearing. I think that you are and this government are deserving of praise for the improvements in access to information that the country has seen over the last 4 years. Those improvements are measured by tangible, objective standards, like the fact that the number of agencies and institutions covered by ATIP has almost doubled since we took office. Roughly 59 new agencies and institutions have been added. In a whole series of departments that were already covered, there have been major improvements in the grading. I look at, for example, the gradings that were offered by previous information commissioners of departments during the previous Liberal government. And I notice that my colleague across the way has made particular reference to your department, Privy Council office, and that according to today's report, PCO received a D. You have acknowledged the need for us to continue to strive more and work hard to improve, but you're building on what we inherited from the previous Liberal government, which was in 2004, PCO was graded F. 2005, F. 2006, F. From that moment, the government took office, and there has been steady improvement. And you have a background in working on access to information. Can you tell us the experience that you have in dealing with ATIP laws prior to your current role as Chief of Staff?
Sure, Chairman. I thank the member for that question, and I won't comment on the statistics to which he's referred. He's asked me my background in access to information privacy law. I guess I've been practicing law almost 20 years now. I was called to the bar in 1991, about 81 days after the Ontario legislature brought into force the first municipal freedom of information or access to information law in the country, and began practicing in that area. Freedom of information, as it's called, provincial jurisdiction, and many of the provinces are access to information, appearing on is one of the first 8 cases decided under the Ontario statute, appearing in court on 2 of the first 5 judicial review applications under that statute. Continued that practice. Shortly before coming here, I was engaged on behalf of a requester as legal counsel in a 4-year struggle to get the City of Toronto to cough up documents related to the major transaction involving the sale of street lights, and won 6 consecutive decisions on that point, fighting obstruction and stonewalling. In fact, this is such a long case that 3 of those 6 decisions, successful decisions under the Act, were argued before I came here, when I was in private practice, and the decisions weren't rendered until after I'd already got here. I have experience as well as a requester, as a third party. Before coming here, I would speak, lecture routinely on this. Mr. Sixay is from British Columbia, where there's a robust law, but Ontario and Prince Edward Island, Ontario where I come from, only two provinces where hospitals and healthcare institutions aren't subject to freedom of information laws or access to information. I was an advocate arguing that hospitals should voluntarily adopt access to information policies to make themselves more transparent and disclosed and accountable. I was a member of the Freedom of Information and Protection of Privacy Association, which is a BC-based society, which is intended to promote and advance the cause of access to government information. In fact, I was a member of that association until the day I took this job, when, by conflict of interest rules, I was required to relinquish it. So I have spent my entire legal career dealing with this area, upholding these principles, and while as a public servant, I'm hired under Section 120 of the Public Service Employment Act. I'm subject to certain restraints. I think my experience and my positions in these matters are a matter of record.
Thank you, Mr. Journeau. 2 minutes remaining. We've seen other departments where there has been a tremendous improvement under this government. For example, in 2004, under the previous Liberal government, the Department of Justice scored an F. In today's report, we found that the Department of Justice has scored an A. In 2004, under the Liberal government, Citizen and Immigration scored a D. In today's report, they scored an A. In 2004, Public Works and Government Services scored a D. In today's report, we have a B. I think you will agree that there has been some improvement since that time, but it does take time to turn a ship around. Would you agree with that?
Yes, I'd agree with that. I'm not going to. I don't think it's appropriate here for me to engage in partisan commentary, but I think it's a matter of fact and of record that there have been demonstrable improvements, both in performance and in policy and in legislation.
The RCMP in the last year of the Liberal government scored an F. That's in 2005. Today, the Royal Canadian Mounted Police scored a C. Again, we remark upon some improvements. So I think the trajectory, you would agree, is on the right track. And you personally held the view that the government should take this issue seriously. The government made changes not only to access but also to lobbying rules. These changes were a key plank of the government campaign commitment. Do you still believe in those changes, and can you tell us why they are so important?
Thank you, Chairman. Absolutely. The member referred to lobbying law. Obviously, I was that was the primary area of my practice before coming here, where I was the law regulating lobbyists, where I was a consistent, clear, and unequivocal champion of stronger, more stringent, tougher rules on the lobbying industry. I think all of the changes in the Federal Accountability Act were necessary because at the end of the day, the government of Canada, government resources, government information, government networks, when we're dealing with lobbying and lobbying restrictions, don't belong to politicians or bureaucrats. They belong to the people of Canada. And that's why those changes were so important.
Mrs. Foote, please. 5 minutes.
Thank you, Mr. Chair, and I too thank Mr. Giorno for appearing before the committee this morning. But having listened to your opening remarks and your responses to some of the questions that have been put to you this morning, I'm having a real problem finding the reality of what you're saying in terms of the real situation, and especially in light of the report that was released this morning by the Interim Information Commissioner. There are two different pictures here. And I'm assuming that given the work that was done by the Interim Information Commissioner, that you too must recognize that what you're saying, and despite the rosy picture being painted by Mr. Polivo, we still have over a majority of the institutions that she looked at who are not, in fact, complying with the Act, that they're having some real serious issues. They're either given a failing grade or there's a red alert on one of those. I want to go back to the situation with Mr. Sparrow, because I guess you make a distinction between requests from the news media and ATIP requests. And I'm wondering what that distinction is, because surely no matter who is requesting the information, the same principle must apply of transparency and accountability. So why would a routine request for information be flagged by the Prime Minister's office or the Minister's office, as was the case with Mr. Sparrow, even if it was just a routine request from the news media?
Chairman, I'll speak first generally about that. As I understand the question was about the difference between media inquiries and requests under the Access to Information Act.
And why they would be treated differently?
Well, the first part of the answer is that in principle there should be no difference. Information should be available, and this is clear from policy from the Act, right? Information that should be disclosable under the Act should be disclosable in the absence of a formal request under the Act. That's an established principle. But when we enter the area of media requests, which are no different than stakeholder requests or other requests not under the Act, it's important to distinguish between requests which involve statistics, facts, data, or information, and requests which involve policy, positions, that sort of thing. To use an example that the staff has heard me use related to the Peace Tower. If a reporter asks how many bricks are in the Peace Tower, that's a statement of fact, and somebody, I'm assuming the Department of Public Works, should provide that answer. But if the question is, what is the government's position on rehabilitation of the Peace Tower? What is the government's position, if any, on the source of materials for renovations? What is the government's position on the budget for renovation? Those sorts of things. Then obviously that's a different kettle of fish. So if a request is for straight facts, obviously facts should be provided. But if a request involves policy, positioning, all of that, essentially a political question about the policy or political positioning of the government, obviously ministers and their offices would be involved in that part of the answer.
What would have been the situation then with the request that Mr. Sparrow dealt with from the media, where they were asking for specifics, for detailed financial information that was readily available, but that Mr. Sparrow or whomever decided that it wasn't going to be made available?
Well,
that was detailed
factual information that was readily available?
Chairman, I'm pausing. The reason I have trouble understanding the question is I believe that the detailed information, which was the budget of the advertising campaign, was in fact provided to the news media outlet in question. So I'm actually confused about if the question, Chairman, is was it provided? I think the answer is yes, it was.
It was delayed by 3 weeks. And the question is, why was it delayed? Why, if the information was readily available, was it not given to the news reporter at the time that the information was requested? The bureaucracy who had been involved said the information was readily available. So why would it not have been released?
Thank you, Chairman. Obviously, that's something that committee members can ask. I know that the minister has been invited to appear before the committee or members of her staff. So it would be probably unwise for me to comment on specific details of situations that I'm not aware of, but I can speak generally about these matters. And
well, that's okay if you don't feel comfortable answering that. I guess I really want to get then to when you're talking about ministers answering questions. You said, if I recall correctly, that in fact the Act had been amended by the Prime Minister to ensure that ministers would in fact comply with ATIP requests.
Okay.
So I'm questioning why, for instance, in natural resources, all but the most routine requests are held up in the minister's office. Where does it show that there's any kind of compliance?
Okay, thank you.
Thank you, Chairman. I think I've answered that question. I think as I've explained, and I referred, for example, to the authority of Mr. Leadbeater. As well, I'll just point out that the previous version of accountable government was something called Guidance for Ministers, and the version of that document issued in November 2003 by the incoming government of Prime Minister Chrétien said as follows, and this is directly responsive to the member's point. This is page 51, section 5.6, en français aussi, à la page.
Also in French, page 51 and 52.
Advised to operate in accordance with the intent as well as the letter of the Act when dealing with requests from the public for information. Here's the key point. And you have the right to expect your department to keep you fully informed of requests for access which are being granted, end quote. So that was the policy of the under Prime Minister Chrétien and also of the two previous Prime Ministers. So there's nothing wrong with informing staff of a minister or the minister that the decision's been made and stuff is going out the door. The key is that process should not involve delay, should not involve alteration of the decision.
Thank you. Mrs. Davidson, please.
Mr. Chair, and thanks very much, Mr. Giorno, for being here this morning and clarifying these issues with us. I know that in your opening statement you said that government takes the access to information requests very seriously, and certainly that's the way it should be, and I was certainly glad to hear you say that. I firmly believe also that the access to information is the public's right and that they need to know that. We've heard some different statistics here today. You know, we've heard some reference to the report that was tabled this morning, and we've heard some rebuttal on what some of the improvements are when you go back and look at some of the other reports that have been tabled. And I think that that's significant. I think that we need to not lose track of that. I think we need to be clear that there have been some improvements made, and I think that we're all certainly free to admit that there need to be more improvements made. So I think that we're heading the right direction. I think the policy is right, and I think that we need to continue on with the Act the way that we intend to. Now, you also said in your opening remarks that these requests are certainly taken very seriously, and they're not to be interfered with by political staff. So, since you've become Chief of Staff, I think it was in 2008 or thereabouts, what have you done to instill the importance of maintaining an open and transparent government among the political staff members?
Thank you, Chairman. Yes, it's almost 2 years that I've been here. I think I arrived, I arrived July 1, 2008. Shortly after that, after the 2008 election, Accountable Government, which addresses these principles, addresses the Access to Information Act, and it addresses the requirement that political staff members not instruct public servants in the exercise of their authority, was reissued. More recently, I have communicated fairly extensively with members of the political staff, both in my own office, the Prime Minister's office, and ministers' offices. I wrote on February 9th to chiefs of staff, reminding of their obligations and their staff's obligations and the restrictions placed on them under the Access to Information Act. I wrote to the Prime Minister's office staff members on February 12th of this year. I wrote again to chiefs of staff on February 12th, this issue. On February 12th, as I said, I said I made the presentation. I'm not sure I said it was on February 12th, but on February 12th, I appeared before the regular meeting of issues management staff and ministers' offices and reminded them of their obligations under the Act. I reminded them of the provisions of accountable government. I reminded them of the provisions of Section 67.1 of the Access to Information Act. And then in March, I wrote again to chiefs of staff, ministers, and asked them to confirm these principles, these expectations with members of their staffs, and asked them to give me a written record of the communications within their offices.
So specifically then, how are the political staff told to treat the information requests?
Well, Chairman, I think the simple request to, the simple response to the members' answer is political staff members are not told to do anything related to an access to information request. They're told to let decisions be made by the members of the public service who have received delegations of authority under the Act, and that's it. No political staff member has received a delegation of authority under the Access to Information Act, and therefore no political staff member has authority to make an access to information decision.
Has that always been the case, that political staff members have never received delegation?
Chairman, it's always been the case that political staff members have not received formal delegations. However, I don't want to stray into partisan territory here because I'm not sure that that's helpful to the discussion, but certainly there is ample evidence, and I'd cite both the findings of Justice Gomery and some of the reports issued by the former Information Commissioner John Reid, which indicate that there was some significant political interference in the access to information process. But leaving that aside, I make that comment not on a partisan basis, it's just a matter of the history of the evolution of access to information law. I think the entire Parliament of Canada has gone beyond that with the reforms that were contained in the Federal Accountability Act, the changes to the access to information policy, which are designed to turn the page on some of that behavior that I think all members of the committee, of all parties, would agree was unfortunate.
Thank you.
Madame Tillac, tu as la parole, s'il vous plaît.
Tillac, you have the floor. Good morning, sir, and thank you for being here today to give evidence. You cited the legislation that we know. Could you perhaps tell us that at no time was there any political interference or any obstruction to a request for transparency? How can you state this? Have you already carried out investigations regarding interference by ministers, yes or no?
Thank you, Chairman. I can state what I know. What I know is that the rules are clear, the expectations are clear, they are constantly reinforced and recommunicated.
No, my question was, have you already carried out an investigation on allegations on the part of ministers, yes or no?
Chairman, I don't understand the premise of the question, or I guess I disagree with the premise of the question. Where there are specific circumstances that require addressing or being looked into, they'd be looked into. But if the member is asking me to whether I've taken steps as a result of anonymous commentary in the Hill Times, the answer is no, and I don't think the member would expect me to do that.
Monsieur le Président, c'était pas...
Mr. Chairman, that was not my question. My question was, have there been any inquiries made regarding, yes or no, whether there was... it's not a matter of finding out whether a position is taken. I wanted to know whether there were investigations or inquiry made in yes or no. That's a very simple, factual question. Yes or no?
Thank you, Chairman. The member may think it's a simple question, but the premise is flawed. There's nothing to investigate. Where there are specifics, obviously specifics will be looked into. If the member has specifics she wants to bring to my attention, I'd be happy to take them back. But the only thing that we've heard today is reference to anonymous commentary in the Hill Times. And if the member's question is, did I launch an investigation on the basis of anonymous commentary in the Hill Times, my answer is no, nor would I expect any member would expect me to.
So you deny then there is a problem and you take no measures to rectify it. When there is information and allegations which are recurring, I believe that it would be your duty to validate that information. You're being offered the possibility of carrying out the house cleaning that you say you wanted to do over the 4 years, and you can make use of this opportunity then to carry out an investigation and shed light on the situation. But you say quite clearly that you have no intention of following up on these allegations made by journalists. However, these are allegations I believe that journalists usually base their articles on facts, and that's what I wanted to find out.
I thank the member now because I do understand the premise of her question. She was asking me whether I intended to follow up on anonymous news tips, and my answer is no.
All right, we seem to be going around in circles. You say that the ministers are responsible for the compliance of the regulations and rules. How is this followed up?
Sorry, Chairman, I'm not sure I understood the question. Each minister is responsible for the duties that have been entrusted to him or her. Subsection 2.1 of Section 4 of the Access to Information Act makes the head of a department, that is the minister, responsible for ensuring that access requests are dealt with accurately, completely, and on a timely fashion. Each minister has signed a delegation of his or her authority to name public servants, but ultimately, and I think I said this earlier, so I refer to my opening statements, obviously the cornerstone of ministerial responsibility is ministers' responsibility to Parliament. So ultimately, ministers are responsible to Parliament to answer for, to speak to how the duties that have been entrusted to them under the statute are being discharged.
Each minister has a discretionary manner then in order to carry out a follow-up? Or is there a code or a rule of behavior which is unique just to ministers?
Chairman, I think the member misunderstands, misperceives what the Act provides. There are very clear principles in the statute. There are mandatory exemptions. There are discretionary exemptions. Where discretionary exemptions might apply, those decisions are made by public servants to whom ministers have delegated specific authorities under the statute. And once delegated, it's those public servants who are making the decisions to apply a discretionary exemption. However, and I think that the member, she and I would both embrace the principle of the supremacy of Parliament, would realize that despite the delegation of authority, ultimately it is the minister who is responsible to Parliament to answer for how delegated authority is being discharged. But in that respect, Chairman, the Access to Information Act is no different than any of the statutes enacted by the Parliament of Canada.
Please.
Thank you very much, Mr. Chair, and I too join my colleagues in welcoming you here this morning. Mr. Giorno, it's good to have you here. I appreciated the history that you gave us in terms of what our government has done with the Federal Accountability Act in pursuing the creation of a unique cultural accountability by strengthening access to information. I also appreciate the fact that my colleague reflected on the improvements that we have made in the last number of years, and I think it's always important to take a look at a report within the context of other reports that have gone before it. And so I appreciate knowing that we have been making tremendous success in the areas of access to information. Another thing that I appreciated hearing from you was that you've experienced these issues on both sides, both from the perspective of a requester as well as someone now who is responsible for ensuring that our government is complying with legislation. What I would like to ask you is if you could tell me a little bit more about your previous law practice and what, if any, relevant experience you had with respect to lobbying laws.
Chairman, I think the members asked an interesting question. She touched on my experience again under access to information or freedom of information. I can say that before coming here as legal counsel dealing with these access to information matters, I and my client have been on the receiving end of political interference, and I had no intention of coming here and allowing it to continue. So I think my record there is very clear. As for lobbying law, the law governing lobbyists, I said I have always been a champion of tough, rigorous, stringent rules governing the conduct of lobbyists. For some reason, the House Committee didn't have any interest in what I had to say, but I appeared before the Senate Committee holding hearings into Bill C-2, the Federal Accountability Act, and spoke specifically on lobbying law and talked about strengthening what was already a very strong bill, mind you. I appeared she appeared by teleconference before the Legislative Committee in the province of Alberta that was considering the introduction of that province's first lobbying act. I have appeared before the city of Toronto's council and also made representations to the Legislative Committee in the province of Ontario urging strengthening of lobbyist regulation at the municipal level. I've been consulted internationally as Republic of Ireland, for example, other OECD countries are interested in adopting their own lobbying law regimes. I have extensive experience, and some said I was one of, I wouldn't necessarily say this myself, but some have said that I was one of the leading experts in Canada on, or at least leading experts outside government on the law and the regulation of the business of lobbying. It's something that before coming here I believed quite passionately in for the reason that I've identified, and that is that whether we're talking about government resources, taxpayers' dollars, or we're talking about government information, government records, or we're talking about the networks that a public servant or a political staff member accumulate, none of that information, none of that money, none of those networks belong to individual politicians or staff members or bureaucrats. They belong to Canadians, and that's why it's important to have a strong lobbying law regime, strong access to information regime, strong accountability rules generally.
Hear, hear. Thank you.
Mr. Sixay.
Thank you, Chair. Mr. Giorno, you've noted that you've had to write a number of times in February and in March, I believe, to political staff to remind them to uphold their obligations to the Access to Information Act. Is it a usual thing that you have to contact political staff to remind them of their obligations under the law?
Chairman, I won't say it's usual or unusual. It's something that is done, and obviously, as one communicates rules and expectations, one is always mindful of the context, and therefore, as circumstances arise which make it advisable to refresh, recommunicate, someone in my position does that.
Why have you had to do it so many times in recent months on access to information?
Well, obviously, Chairman, this is an interest of a topic, of interest to the committee. It's a topic of interest to the committee. It's a topic of interest to me, and just as the committee has seen this as a priority, something that's relevant and on the committee's mind for obvious reasons. In early 2010, it was also on my mind for probably the same reasons, and that's why I felt the need to to reissue those communications.
So, Mr. Journal, you still insist that you weren't taking those actions in light of news reports and stories that have appeared in the media exposing problems with access to information? Weren't those exactly the stimulus that caused you to have to remind political staff of the government's commitments and their obligations under access to information?
Chairman, the member's question allows me to repeat, but to clarify a previous answer. I was referring to anonymous commentary in media stories, and my position on anonymous commentary remains the same. If the member is referring to non-anonymous commentary, that is reports of facts, I, like everybody else in the city, take cognizance of what is happening and act accordingly. The committee has an interest in this topic, renewed because of recent events. My communication was renewed in light of circumstances.
It would be interesting to see the timing of your reminders and the news stories that came out. Mr. Giorno, can you explain to me the role of the issues management wing of the PMO?
Yep. Thank you, Chairman. I think I've answered that. The issues management staff is responsible, as I said, for helping to prepare the Prime Minister to participate in question period. In that respect, their role is no different than that of Prime Minister's offices in previous ministries. They help to prepare other ministers. They work with the staffs of other ministers to help ensure other ministers are prepared for question period. But because questions are raised and accountability is expected, not just during question period when the House of Commons is sitting, accountability is required at all times, every day, 52 weeks of the year, 7 days of the week, 24 hours a day. Questions may be asked by a reporter, by a stakeholder, by otherwise. They perform a similar function when the House of Commons is not sitting. There's no question period. That is, preparing and assisting the Prime Minister to answer questions, or working with the staffs of ministers to ensure that they're prepared to answer questions about what is usually au courant or topical.
Now, would that branch of the Prime Minister's office ever give verbal directions on slowing down, delaying, stopping ATIPs altogether, or transferring ATIPs to the centre?
Yeah, I think I've answered that, Chairman. The responsibility for access information has been delegated by each Minister of the Crown to specifically named public servants. They're named in the delegation orders. Those delegation orders are, as far as I understand, publicly available on each department's website. No political staff member has received a delegation of authority under the Access to Information Act, and therefore no political staff member is entitled to make access to information decisions. And further, the Prime Minister's own rules in accountable government provide at page 37, from which I read in French, and I read in English, quote, exempt staff.
And we did hear
exempt staff members do not have the authority to give direction to public servants, but they can ask for information or transmit the minister's instructions, normally through the deputy minister.
Were political staff who gave any pushback to issue management staff in the briefings that they have, with the regular briefings they have, were those political staff ever insulted on the phone before all their colleagues if they contradicted or questioned any of the advice on ATIP that was being given to political staff by issue management staff?
Chairman, similar question, same answer. The rule is clear. Responsibility for access to information has been delegated to specifically named public servants. No political staff member has received such a delegation of authority under the Act, and therefore no political staff member should be making access to information decisions, and no political staff member should be instructing public servants in the discharge of their responsibilities under the Act, and it would stand to reason that nobody should suffer any adverse consequences for complying with the rules in accountable government.
Mr. General, what would
Mr. Sixay. Thank you. Mr. Valeriot, please.
Mr. Journal, you indicated that you don't investigate non-specific allegations of a violation of the Act that might be found in a news report. Now, Mr. Togneri was a specific case. Can you tell me, to the extent that you investigated his de-releasing of a report that was otherwise released, and if you investigated that, what was the result?
Chairman, thank you. The member asked about the specific question of Mr. Togneri. That is, as the member will know, the subject of an investigation by the Information Commissioner, so it would be sort of inappropriate for me to comment on something that she is investigating. I will say this in response to the question, however. I believe that the news story, the media story, which covered the issue, broke or appeared on The Wire on Sunday afternoon, February 7th. The article was brought to my attention at that point, so that's when I first learned about it.
Okay.
There was follow-up. I won't speak to the specifics of what happened, but I think the current Minister of Natural Resources has already made clear of the steps that he took within his office to address that situation.
All right, thank you. Now, just for the record, in response to Mr. Poilievre's comments about the record of this Conservative government, it should be noted that a percentage of requests where all information is disclosed has fallen dramatically since this government has come into power, and the percentage of complaints filed with the Information Commissioner has increased dramatically. So I think we need to set the record straight. But having said that, in this morning's press conference, the Information Commissioner said that there is a lack of will to be transparent. She also said that Canada is no longer a transparency leader. Now, this is Canada's Information Commissioner. She also said that we need to change the legislation, essentially, to force the government to comply with time requirements. What that tells me is, notwithstanding that you may have been operative in creating this kind of law when you were practicing law, it tells me that just because you participated in making the law doesn't mean you feel a necessity to comply with it. And frankly, Mr. Journo, it seems to me that the only reason the Information Commissioner would recommend changing the law is because of this government's systemic problem that it has with always bending and pushing the envelope at every level. Now, could you tell me why you would think the Information Commissioner would want to change the law to force compliance? And if that is a valid request, would you suggest to the Prime Minister that he change the law?
Well, the Chairman, if the member is asking me to get inside the head of the Information Commissioner, I won't purport to do that. I will state, however, though, that as an independent officer of Parliament, the Information Commissioner is held in high regard, and I certainly, and the government has a lot of respect for her advice. And so any advice given by the Information Commissioner will be taken by the government and reviewed, and the government will look at her recommendations quite carefully. But if the member is asking about a particular reform that would sort of such as that I understand from the member has been proposed, it sounds very similar to a proposal that's existed for a few years, and I think it was November 15th, 2005. It's in the Journal's Division 180, where members of the Liberal Party voted against such a recommendation. So, Chairman, I'm not sure whether the member is asking me what the government's position is on something that the Liberal caucus voted against 5 years ago.
Well, Mr. Journo, let's be clear. We're talking about facts today, not facts of 2005, and we're talking about this government's non-compliance with the legislation today. Well, that's what's important. That's the issue before us today. So let me ask you another question. To be absolutely clear, are you denying that any instruction or direction was ever given to any political staff to interfere in any way with any access request, either generally by the press or under the Act?
Well, Chairman, I disagree with the member. That's why I talked about my background, and I was happy to do so, because I think the past does matter. I believe very strongly.
That's not the question, Mr.
I believe
Journo.
very
I'm
strongly.
asking you to answer the question.
I believe very strongly in access to information, and I do not believe that access to information is a political football to be shunned while in government and embraced only in opposition. It's a principle that applies at all times. That's why this government came in, turned the page on what had happened in the past, brought in the toughest anti-corruption law in Canadian history, improved and strengthened the Access to Information Act, improved a much weaker under the previous government access to information policy. That's why those changes were made, and that's why they're important. I accept the premise that there is always more to do, but I don't accept the premise that one can, jump back and forth and change a position on such a vital matter, which the courts have identified is not just any law, is actually quasi-constitutional in nature because it is so important to the very fabric of our democracy.
I'll ask the question
order,
again.
Order. Sorry, Mr. Floyd, unfortunately your time is up. We have to move to Mr. Rickford, please.
Merci, Monsieur le Président, et bonjour, Monsieur.
Thank you, Chairman. Hello, Mr. Journo. We'd like to thank you for having taken time from your very heavy schedule to come here. I have two questions this morning, but some deal with the context and your experience with the matter before us today. I know that you're a lawyer, and according to your practice, no doubt, this is one of the reasons why you're so highly qualified for the position of Chief of Staff to the Prime Minister. We know that you are fully informed of the legislation and acts which apply to the government's accountability and the lobbying and anti-corruption, for example. So my questions are as follows.
Expand a bit on those substantive pieces, namely government accountability, lobbying, anti-corruption, and tell us how the Federal Accountability Act helped to address them more fully.
Chairman, the members asked me to talk about some of the changes, or talk further about some of the changes that were contained in the Federal Accountability Act. First of all, I'll start by talking about access to information before turning to other areas. There are a number of other changes to the Access to Information Act, which even today haven't received, I think, the attention and the publicity that they should. The definition of record was updated in the statute, and that's important because the old definition of record used to be restricted to there's a long list of different types of media, different forms in which information could be contained in records, and in order to make the Act technology neutral, or to allow it to keep up with the advances in technology as information keeping and record keeping practices changes, it now has a very simple definition. Remove the long list, and it says record means any documentary material regardless of medium or form. And of course that's a pro-access improvement, because it means that as technology changes, everything in government's possession is subject to the Act. The Federal Accountability Act also added a new section to the Access to Information Act, I believe it was section 72.1, which provides as follows. The head of a department or a ministry of state, in other words, cabinet minister, shall publish an annual report of all expenses incurred by his or her office and paid out of the Consolidated Revenue Fund. That, again, is new in the Federal Accountability Act. The Act also added a new paragraph to subsection 71, providing that the minister responsible shall, I quote, cause statistics to be collected on an annual basis for the purpose of assessing the compliance of government institutions with the provisions of the Act and the regulations relating to access. And finally, and this is probably the most significant of the reforms, apart from nearly doubling the list of entities, it was members have asked about this, Chairman, earlier today, whether, and there were certain well-documented concerns prior to 2006 that different types of requesters, news media, opposition researchers, were treated differently. And of course, that's not what the Act provides. The Act provides that the processing of requests should be applicant blind, to use a term that's used in the United Kingdom in their freedom of information legislation. So what was added in subsection 2.1 of section 4 was a requirement, crystallizing the requirement that the processing of requests should be, and I quote, without regard to the identity of a person making a request for access to a record under the control of the institution. And that was intended to address well-documented and legitimate concerns about different access being given to different types of requesters. I mean, the courts have made clear, and this is the principle of not just this Act, but freedom of information legislation in the provinces and around the world, and that is that if Fred makes a request for a record, he should receive the same decision as Sally, as should John, as should as should Jane, and that when a news reporter makes a request, he should receive the same determination under the statute as an opposition researcher, as a stakeholder, as an ordinary citizen. And so clarifying that and improving the access to information policy were, I think, important reforms. And I apologize, Chairman, because I don't even have time to talk about the non-access to information changes in the Federal Accountability Act.
Another time, possibly. All right, colleagues, I can't accommodate everyone, but I want to be fair and balance this. We have enough time to go through the third round, but at 3 minutes, that's basically one question per questioner. Okay, 3 minutes. We have Madam Foote, Mr. Polyev, Madam Freeman, Mr. Bazin, Mr. Sixay, Mr. Valerian, I believe, and Mr. Polyev will end it off. Okay, there's 7 people, 3 minutes, we're done. Okay, Madam, yes.
Monsieur le Président.
Mr. Chairman, I don't understand. The third round, how is it being distributed?
Instead of 5-minute round, it's a 3-minute round. Okay, carry on. Let's go. Madam Foote.
Thank you, Mr. Chair. I guess I want to go back to the question that my colleague asked earlier, and that was just what, to be absolutely clear, you are denying that any instruction or direction was ever given to any political staff to interfere with any access request, either generally of a routine nature or under the Act.
Chairman, I think the member inadvertently is putting words in my mouth. I can speak to what I know. What I know is the policy and the expectation, both of the Prime Minister and of me. Those expectations, those rules have been communicated and recommunicated. They're very clear. No political staff member has received a delegation of authority under the Access to Information Act. No political staff member has authority to make access to information decisions.
Okay, so are you aware of any cases then where staff has in fact interfered in either media requests for information or requests under the Access to Information Act?
Well, Chairman, I've already answered this question, but to return, one has to distinguish. I understand the member in her question may think that media requests not under the Act and requests under the Act are to be treated identically, and they are slightly different. As I explained, there is a good reason, Chairman, for requests from the media, just like requests from stakeholders or requests from other people, not under the Act that relate to government policy or positions, would of course have the involvement of the Minister's office and the Minister, because ultimately it's not a nonpartisan public servant who can be expected to give a reporter or a stakeholder an explanation of the position, the political position of the government on a particular matter.
I guess I'm trying to get some clarification, because you look at the Togneri situation. So other than Togneri, which you say now is being investigated by the Commissioner, are there any other examples that you're aware of where there's been interference?
Chairman, I repeat my previous answer, although I invite the member, if she has those examples, to bring them to my attention.
So,
go ahead. As long as you're quick.
So, to the best of your knowledge at this point in time, there has been no interference by any political staff in any request for information, whether routinely or under the Act?
Chairman, a similar question, in fact the same question, the same answer is the expectations of the Prime Minister, the expectations of me are clear and are constantly communicated. If the member has a specific example, I would be happy to, and in fact if there was a specific example, I'd be happy to take that up with the Minister in question.
Okay. Mr. Polyev, please.
Mr. Giorno, you've had occasion to talk to us about the experience that you've accumulated as a private citizen prior to becoming Chief of Staff to the Right Honourable Prime Minister. And in your role, you've seen the ratings of certain departments experience improvements under the Access to Information Act. Look at the Department of Justice, for example, which went from an F in 04 to an A in today's 2008-2009 rating by institution. What, in your view, has led to these improvements?
Chairman, I'll be consistent in my answering. Decisions about the Access to Information Act are made by members of the nonpartisan public service who've received specific delegations of authority. They do so without taking instructions from political staff members, because it's inappropriate for a political staff member to give instructions. It would be a violation of accountable government, and of course no political staff member has received a delegation of authority under the Access to Information Act. Therefore, no political staff member has authority to make access to information decisions. It therefore follows that any credit for these improvements is largely goes to the credit of the public servants who are making this decision and their deputy ministers. So, on behalf of, he's not here, the Clerk of the Privy Council, who is also former Secretary of the Treasury Board, specifically responsible for access to information, I'll accept your compliment and pass it on. But really, it's deputy ministers, Clerk of the Privy Council, the Secretary of the Treasury Board, who are responsible for ensuring that those public servants are complying with the Act and discharging their responsibilities.
So, in other words, we've had this government has enjoyed a fruitful relationship, working relationship with the public service and delivered successes because of that hard work. And I think you're quite right to give credit where it is due with the public servants, the hard-working public servants who are administering these rules properly. Now, you commented extensively on the Federal Accountability Act, but you were constrained by time. I want to give you occasion to highlight other areas that you think deserve to be underlined, given your experience in the area of access.
Well, thank you, Chairman. I would suggest the member might look at the changes to the Lobbying Act, well, taking what was called the Lobbyist Registration Act and renaming it the Lobbying Act, taking the former registrar, who was an employee of the Department of Industry, and making him, now her, an officer of Parliament. So, having that protection, that independence, that autonomy, an important change. The 5-year ban on lobbying by former designated public officials is another key reform. Changes to the Canada Elections Act to remove the influence of big money. No more secret trust funds, no more big money donations, no more corporate and union contributions, another change. There were, of course, complementary changes to the Privacy Act and a number of other statutes in that respect. And then the changes to procurement practices, advertising, polling, contracting. All of those are changes in the Act that are worthy of mention. The Federal Accountability Act, a lot of hard work put in by all members of all parties in both houses of Parliament, but it stands on the books as I said, the most comprehensive anti-corruption law in the history of Canada.
Thank you. Madam Freeman, s'il vous plaît.
Yes, hello again. I'd like to continue. As a result of what Mr. Poilievre just said, Privy Council receiving access to information refuses to answer 1 out of 5 requests and takes 5 times more time than covered by legislation when an answer is provided. So this then was my comment, but my specific question is regarding the question asked by my colleague, Madame Silak and Ms. Foote, asking you whether you have a specific example where there has been interference on the part of political staff. And I'd like to refer you to the accusations of interference in the Canadian press and many Canadian newspapers. Under the Access to Information Act, a request was made regarding the use of federal buildings when Mr. Paradis was the minister responsible. And a political employee, Sébastien Tonieri, ordered that the release be intercepted. Are you aware of this event? Or were you aware? And if you were aware, what measures did you take? Because Mr. Tonieri is still occupying his position.
Est-ce que ma question est claire?
Is my question clear this time? Because I think it's 3 times that you're being asked the question and you never answer.
Chairman, I think the first one members asked many questions. I think each of the sub-questions is clear, but many of them are answered with the same answers as before.
Je m'excuse, Monsieur le Président.
I'm sorry, Mr. Chairman, we're on my time, and my question is very clear.
To let the witness please to have an opportunity just to respond, and you will have some time to ask your one last question.
The minister, excuse me, Chairman. The member asked a general question about the conduct of the staff members. I can speak to my conduct, my expectations. I refer to my previous answers. My expectations as the Prime Minister are clear and constantly communicated. The member referred to the Privy Council office. Obviously, that is something that's of concern, but the clerk of the Privy Council could speak to that in more detail. As to the question. The third question of Mr.
To order, Mr. Chairman.
I'm going to let him answer. You have time for another question.
Mr. Chairman, my question, I am a member of Parliament and I have a right to a certain number of minutes and it is my time. And if the witness doesn't want to answer my questions and doesn't want to answer clearly, Mr. Chairman, I was asking my question quickly. He refused to answer Ms. Foote for the same question, who wanted a specific example. I provided him with a specific example. So my question was he aware, yes or no? Because he wanted an example, and it is quite simple. He can answer yes or no. And what were the measures he took if he was aware? And I think that's my time. Thank you, Mr. Chairman.
No, just a moment. No, just a moment. Just a moment. Just a moment. Okay. Our practice has always been proportionality, and to ask for a yes and no in some cases requires some explanation, and we give that latitude to the witness. But, Madame, I stopped the clock to make sure you have another question. I think Mr. Giorno is almost. He did. There was 3 elements to your first intervention. He was on the 3rd one to give the answer. In fairness, I have to give him an opportunity to complete the answer to the 3rd element, and then I'm going to go back to you for one more question if you wish, okay? And that is about splitting the time evenly between questioner.
Mr. Chairman, my question, there were not 3 elements in my question, there was just 1.
Yes, and I apologize, Mr. Chairman. I've appeared before committees before. This is the first time I've appeared in my current role, and sometimes witnesses have difficulty distinguishing between preambles and questions. But in response to the 3rd element of the question related to Mr. Tonieri, I first learned about the situation sometime in the afternoon of Sunday, February 7th, when the media story ran. I think it ran between 3 and 4 p.m. Whether I looked at my BlackBerry between 3 and 4 or later that evening, I was first aware of that. Obviously, this is something that is being investigated by the Information Commissioner, so I don't want to go too far into drawing conclusions. I will say that the current Minister of Natural Resources has talked about the changes that have been made within his immediate office in response to this. Other than that, it would be inappropriate for me to comment on any disciplinary action that may have been taken because that's sort of personal information. But the comments of the Minister of Natural Resources are clear and I believe on the public record.
Thank you. Madame, you have 1 more minute, okay?
So if I will understand, you were informed about the event and the facts, but you did not intervene because it was up to the Minister to do so.
Oh, that's Chairman, that's a...
Ce que je viens de dire.
What I've just said is legal terms. You're a lawyer. I'm a lawyer myself, so you cannot pretend not to understand the terminology that I've been using, nor the question that I'm asking.
I think
J'espère.
J'espère aussi. aussi. That's.
I hope so.
Chairman, the member shouldn't mistake my disagreement with her premise for lack of understanding. I was made aware of the situation by a news report which came out on Sunday, February 7th. So that was after the events. I became aware of it then, and it was after that action was taken.
Thank you. Mr. Bazan, please.
Chair, on point of order is raised, I believe that it's the responsibility of the Chair to accept those point of order, but I'm going to make use of my time judiciously, and I want to thank Mr. Journo for appearing before committee today, for showing that his knowledge is very well-founded in access to information and privacy legislation, that he's been very clear in his answers and provided clarity to the discussion that's taken place here today. And I also appreciate his personal convictions to ensure that not only the Act as it stands today under the Accountability Act, but also the spirit of the Act is respected by Parliament and by ministers. So I do appreciate that. And I also want to congratulate him for his role in being diligent to ensure that he trains staff and goes over those rules and explains to them their fiduciary duty in providing access to information on behalf of Canadians. And I think that that was a very important role, and I do want to congratulate you for taking that on. Now, as we know, you not only as Chief of Staff to the Prime Minister, but you described your involvement as a lawyer in access to information legislation, and that you were previously employed at the provincial level as well. And so I'm just wondering if you'd be able to have any discussion on any personal experiences that you might have had to deal with in the past with political interference in trying to obtain access to information.
Chairman, I referred to the 4-year battle with the City of Toronto involving 6 separate decisions related to the sale of the streetlights, and it was certainly our belief that a large part of the stonewalling and the destruction there was the result of political interference, municipal interference. And so, as I said, I didn't leave private practice, and I expect to come here having championed openness and transparency and fought political interference to allow anything differently here. That's why I was pleased that the Rules and Accountable Government were clear that the expectation that the Access to Information Act would be upheld. The Access to Information Act already having been strengthened by the Federal Accountability Act. The rule against not instructing public servants very clear in accountable government. So I have continued to communicate those expectations and to make very clear where I stand and where the Prime Minister stands on these matters.
In time?
Half a minute.
Okay, and you're referring earlier, Mr. Journo, to the rules that the Treasury Board have also brought in, which clearly describe the prohibition of political staff in making ETHI determinations. So those rules are binding upon all staff employed through ministers' offices?
Chairman, to be clear, I think the governing authority is accountable government. That's compliance with that's a condition of continued employment for all political staff members. The Treasury Board policy on access to information is inspired by that, and it's also binding. But I would say the more important document is accountable government, because Section 6.1.2 of the Treasury Board policy states that, and I'm quoting part, that only the head of the institution, the named officers, may exercise that authority, but that's not as clear a prohibition as in Section 6.1 of accountable government, which I've read for members of the committee.
Thank you.
Thank you, Chair. Mr. Journo, as much as I like a good tennis match, seeing the Conservatives and Liberals go back and forth about you were bad, no, you were worse, I look forward to the day when maybe it's, oh, we were great, no, we were better on this issue. Certainly we're not there yet. I also have to say that I always enjoy a very partisan guy struggling to be nonpartisan, and it's been interesting to watch you in that role this morning. But I have to say, the Liberal government isn't the standard around access to information. And I think the standard around access to information is easily the Conservative Party's own platform in the 2006 election. And I think anyone who has any interest in access to information would agree that that was a very well and thought-out, comprehensive platform. And I suspect, given your own personal interest in access to information that we've heard about this morning, you're well aware of that platform. Now, it had 8 points. When I look at that, and when I've questioned witnesses since I've been on this committee, it appears that the Conservatives have only done one. the Accountability Act and the expansion to all Crown corporations. We haven't seen an introduction of the Information Commissioner's proposed changes, reforms to the Information Act. We haven't seen the Commissioner get the power to order release of information. We haven't seen Cabinet conferences that are excluded reviewed by the Information Commissioner. We haven't seen public officials obliged to create records necessary. We haven't seen a public interest override for all exemptions. We haven't ensured that exemptions from the disclosure of government information are justified only on the basis of a harm or injury that would result from that disclosure. And we haven't ensured that disclosure requirements for access to information can't be circumvented by secrecy provisions and other federal acts. So it strikes me that by that standard, you're not doing as well as you'd like us to believe. What's your comment on that? What's the plan? Is there a significant commitment, or have Conservatives forgot what it was like to be in opposition, how important access to information is to the functioning of Parliament and to our democracy?
Chairman, if the question is asking me to rate the improvements, I don't think it's my place to do that. I know that members of the committee have been discussing this for a long way. I accept at least this part of the premise of the question, and that is that there have been improvements. And I know that members of the committee on all sides have been, debating for many years whether there's more to do and what to do. I think the specific answer to the specific question is that the Minister of Justice has responsibility for the government's access to information policy. I'm referring to the policy of what the legislation ought to say and ought to read, and I would invite members of the committee to address those specific questions to him, although I note, as the member correctly identifies, I do follow this issue, and I know this has been an ongoing debate among members of the committee for many, many years.
To a number of memos that you've sent to staff about their need to comply with the legislation. Would you be willing to provide those memos, copies of those memos, to this committee?
I'd be pleased to do so in both official languages.
Thank you, Mr. Chairman. Another question. Are there other cases, any other cases, that are not now public, not publicly known, not either reported in the press or otherwise, where there has been any political staff interfering in an access to information request?
Chairman, a similar question. I think I've already answered that. I can speak to my conduct to the extent of my knowledge. I can speak to what the expectations that I have and how they've been communicated. Those are also the expectations and the standards and the rules of the Prime Minister.
Can you speak to your knowledge then?
I can speak to my knowledge. The rules are very clear. Ministers have delegated their authority under the Access to Information Act to specifically named public servants. Those public servants are the ones who are responsible for making access to information decisions. No member of the political staff has received a delegation under the Act, and therefore no political staff member has authority to make an access to information decision.
So none have, then? You're telling me none have. I know the rules. I want to hear you say yes or no. None have.
I think that's been asked many times, Chairman. I think I've answered it many times. I'm here. I can speak to my conduct and my knowledge.
Okay.
My conduct, my knowledge, my expectations are quite clear. They've been communicated many times. They're also the expectations of the Prime Minister. No political staff member has authority to make access to information decisions, and it is a breach of the rules in accountable government for a political staff member to give instructions to a political staff member related to an access to information decision.
Are you aware of anyone breaking those rules? Yes or no? I'm looking for a simple answer.
But under the rules, under the rules of Brian Bosk, Mr. Chair,
just a minute.
I'm raising a point of order.
First, yeah, okay. But first of all, just a minute. First of all, we have to turn off his mic and get him to stop talking. Okay? I want him to stop the clock so that he doesn't lose the rest of his time. And then I'm going to go over here and recognize Mr. Bazant on a point of order.
Thank you. And this is a point of order. I believe that as I described earlier, in Chapter 20 of O'Brien Bosk, starting on page 1068, going on to 1069, the public servants can decline an answer to specific questions, and then Mr. Velarde is badgering him on trying to get him to answer a legal opinion or something that definitely the witness has already said that is not in his knowledge and something that is outside of his area of responsibility. And then the common practice and the one that's described in our rules and procedures procedure is that we excuse a witness from having to answer it. And now, what we have here is a member badgering a witness, and I don't believe that
Sure.
is in line, and I think you need to call him to order on it.
Sure. No, Mr. Bazin, you're quite right. When a witness appears before a committee, refusal to answer is not applicable. However, if a witness cannot, because it is beyond their responsibilities or scope, there's good reason, the witness would then raise that with the chair, and the chair will determine whether or not the witness will be permitted not to hazard a guess. It's not for us to make that decision for the witness, because those are the essence of the rules, but it is ultimately up to the witness to determine whether or not they're going to stray beyond their knowledge or expertise.
In that case, then, Mr. Chair, if I may, if we want him to go beyond that, then if we read the rules the way they're drafted up, it's actually the committee's decision, and if they want to get some fairly confidential type of information, then we have at the committee's discretion to allow the witness to testify in camera. And if that's the desire, then that's the way we go. Otherwise, it's out of order.
Sure. Well, let's put it this way. He can ask any question that he wants, but if the witness is unable to or cannot because it violates some other prescription, he can say so, and the chair will rule on that. But it's not for us to make the decision for the witness. And we had this in the Maroney-Schreiber hearings several times as well, and we respected that rule. I think that everybody understands. Mr. Giorno is quite familiar with what he can and cannot deal with, and I think you have any more to say on the last little question that Mr. Verlight, because he does have 1 minute left to ask one more question.
Thank you, Chairman. I think I've answered the question already. I can't comment on the specific Tony Reid matter. I told committee members when I became aware of it. I referred to the fact that the Minister of Natural Resources has communicated what's been taken. Other than that, I'm not going to comment about discipline or potential discipline because it's a personal matter, and I'm not going to comment on an ongoing investigation by the Information Commissioner, although I will add that I am, as I expect all members of the committee are as well, looking forward to receiving her findings.
Can I ask one more question, Mr. Giorno, then?
I'm sorry. Mr. Giorno, please complete your sentence.
I was going to say, again, as to my conduct, my practice, my expectations, I've answered that many times. They're clear. And, in fact, I was pleased to appear before the committee for that reason, because my expectations are clear. My conduct has been clear since I came here on July 1st.
Thank you. Finally, Mr. Polyev.
I think that concludes my questioning.
Thank you. Mr. Giorno, thank you on my behalf for appearing and for responding to the members' questions. There's only one issue that I would like to raise with you. It's something that I think has come up, and you may be able to assist. It has to do with the fact that the position of Information Commissioner has been vacant for 9 months. It's a significant delay. I know that there were a number of candidates. I don't know who they are. I do know that the current acting commissioner is one of the candidates. But I do know that with a 7-year appointment, a new appointee, once they get that appointment, can root themselves into a 7-year plan to do a good job on behalf of Canadians. And the delay is causing some concern. So if there's anything you can possibly do to encourage those responsible to complete that process, I think you understand what I'm asking, that it is of concern, and I hope that we would be able to see that position filled within a reasonable time.
I thank you, Chairman, for those comments, and I will take them back. I'll simply say that two things, obviously, as you're aware, and you've alluded to this, the appointment of officers of Parliament is something that involves all parties in the House, and that's known. But the second point is implicit in your remarks is the fact that the Parliament of Canada has decided to make a position that of an officer of Parliament actually does indicate the significance and importance to the country and to the Parliament of that position, and therefore your comments about the importance of that position are very well taken.
Thank you. We're adjourned.